Adrian East. Thank you, sir. Is Travis Skinner here? All right, Mr. Skinner. Is Miss Bailey here, Megan Bailey? Is Charles Campbell here? And Haley Gandy? All right, in just a moment, I'm going to bring you up and reset all of your cases. Mr. Sanders is ill, unable to be in court today, so I'll call your cases first. I'll get you reset and get you on your way, okay? Christopher Morgan. Christopher John Morgan. It'd be sad if he didn't show up for that. Albert Reyna. Calixto Rosa. You've been informed by the court?
By the court.
Oh. Wendy Paul. Miss Paul, I would like to have you drug tested this morning. If you'll come up and have a seat in the jury box, please. Randy Dobbins. Randy Lee Dobbins. Oh, motion for continuance filed. That's set for pretrial on August 10th. Is Grace Fowler here? All right, Ms. Fowler, Mr. Ashmore is not going to be here. I'll bring you up in just a moment. Jason Nichols. Same for you, Mr. Nichols, on Mr. Ashmore. I'll bring you up in just a moment and reset your case. Joseph Couch. Joseph Brian Couch. Any idea, Mr. Newell? Michael Covey. Michael Shane Covey. For the record, CR 2156, Robert Crane is verified in Wood County. All right, we'll call this case again in a moment. We'll just get it set for status. Amanda Templeton is appearing via Zoom, and she is in the court's online waiting room. Rochelle Kofer. Rochelle Lynette Kofer. Jessica Sotolo. Where? All right, Ms. Sotolo, I'm going to have you come up and have a seat in the jury box. I'm going to administer a drug test. James Bustamante. James Daniel Bustamante. Daniel Garcia. Stacy Heflin. Jason Hodebeck. Charles Howard. Charles Justin Howard. John Lewis. All right, Mr. Lewis, come up and have a seat in the jury box. Christopher Mata. Douglas Mercer. Douglas Keith Mercer. Derek Piscata. Justin Reed. John Rigney. Mark Vargas. Aaron Blevins. Thank you, sir. David McLaren. All right, is there anyone in the courtroom whose name I've not called? Your name? Say again. Yeah, I called your name earlier, Mr. Shapiro. Did you not hear it? That's why you didn't hear it. Court starts at 9 o'clock, Mr. Shapiro, with or without you. You understand? Anyone else? Your name, sir? Yes, thank you, Ms. Beasley. Anyone else? Your name, sir? Yes, Mr. Bird. Have you, either one of your attorneys here today, Mr. Gimbel or Mr. Harden? Anyone else? All right, counsel, if anyone's ready, we'll line up. You may. Counsel, anyone that's ready can line up over here to the left and I'll call you up.
Judge, I made a grave error. There are two Mr. Blevins on the docket today who are both pending MTRs for the exact same charge, but they have different first names. Mr. Bill Stevens came this morning and told me he was here on Mr. Blevins' ag assault MTR. I told him Mr. Blevins had retained Mr. Wells, and so Mr. Stevens left to make a doctor's appointment. There's two, yes, there's two Mr. Blevinses on the docket. That was my mistake. I told him he had been retained by Mr. Wells. So Bill was here, but he did leave.
Did you call him? Yeah, go ahead and call him and let him know, and let's see if. Oh, you do? Okay. Do you want me to have them? Do you want me to have them meet you outside? You just call them outside, let them clean in. You just have them sign. Casey Dobbins said 8:10 for pre-trial. Okay. 7-6. Doctor call. 7-6 pre-trial. Okay, and then Jeff, let's go ahead and look at that just to make sure. Yep.
Charles Campbell, 7:13.
Yes. Did you say plea on somebody? Both if you want, I'm not sure. And then Travis Skinner, 7:13. I've got status. Which yeah, it's victim toxicology, so you just put status on that one. Yeah. All right, so I'm gonna tell all of them to meet you outside. All right, if I call your names, I want you to step outside and meet with Miss Taberham here That means your attorney's not here today and she's going to have a reset form for you. This is going to affect Mr. Casey Ashmore's clients and Mr. Jeff Sanders' clients. Okay, so listen for your name. Megan Bailey, Charles Campbell, Haley Gandy, Travis Skinner, Randy Dobbins, Grace Fowler, Jason Nichols. If I called your name, step out in the hallway and get your notice of resetting. You're free to go. Aaron Joseph Blevin, CR 16-8. If you'll make your way to the center podium, please, sir. Or Mr. Wells, you may.
This is NPR. We're working diligently to resolve it. And we've asked for a reset. He's trying to get records from other things. He had a suicide. He's trying to get records. We've showed he's paid his fees. He has, not all of them. And we showed the ability. This is the doctor, but so we want one reset to get these records. He's had trouble trying to get them over the phone just because of HIPAA. So they want to come out there in person next week.
Okay. States in agreement.
They've sent it already.
Okay.
I just didn't know what you wanted to call it.
Oh, well, it'll still be the motion to revoke. So
You want them to contest it?
no, you can do others, but MTR, and then I'll set you before the contested. But how long do you think it's going to take for me to get those records?
Is 30 days too long for you? I mean, that works. I don't know when you do your documents.
I try not to go more than 30 days. August, I've got, in August, I'd be looking at August 10th and 12th.
Let's do the 12th if that works for you.
12th. Yeah, that'd be fine. All right, Mr. Blevins, I'm going to continue your case until August 12th on your motion to revoke. Mr. Wells is going to have you sign this form. He hasn't already. After you receive that, you're free to go. Remember, you're still on community supervision. Still have to be checking in, reporting, drug testing, doing community service, all the things that you've been ordered to do. Okay. All right. Once you get that yellow copy and Mr. Wells is done with you, you're free to go. Mr. Noel, you ready? Mr. Templeton, if you'll just unmute your device. Good morning. Can you see and hear me okay?
Yes, I can.
All right, Mr. Knoll, if you'll step in front of the camera so she can see you. All right, this is cause number CR 29-1, State versus Amanda Templeton. We're set for docket call today, and Ms. Templeton is appearing via Zoom due to an illness and has been approved by the court. Go ahead, Mr. Knoll.
Stood there, thinking the last appearance, there were some records that Ms. Templeton and I believe her mother were together that might help with negotiations as far as the plea. I don't have those records yet. I would ask for one more reset so that we can come to a resolution on where we're going to take. She did again call me, I think, for a call this morning at 7:43. Eventually, I returned that call to the sale. I told her to call in court. That's what we are.
Any objection from the state? Okay. All right, we'll reset Ms. Templeton then for August 12th, unless you want it set sooner.
Well,
You have your calendar with you? You want to check that? I'd rather you,
I'm back from Savannah. Yeah, I'm good.
okay. All right, so Ms. Templeton, I'm going to set you for a docket call on August 12th at 9 a.m. Ms. Templeton, I do show that you are delinquent in your pretrial release supervision fees. So I'm going to order you as soon as you are no longer ill to report to the Van Zandt County Pretrial Release Office. And you need to make a payment on that. Otherwise, when you come back on the 12th, the court's going to perhaps take up whether or not you should be on bail in this case. That's a condition of your bond, is that you make these payments so that you can cover the cost of your court-appointed attorney and your supervision. If you're not going to pay those, then I'm not going to have you on bond.
Okay.
Okay?
Yes, sir.
So
Yes, sir.
I show you're delinquent $120. So if you don't get that taken care of, then I'm just going to remove those conditions and place you back in custody.
Yes, sir.
All right. So as soon as you're no longer ill, report and get that done. And it needs to be done as quickly as possible. We'll see you back on August 12th at 9 a.m. You're free to go.
Where is it at?
Where's what?
Thank you. Where am I supposed to pay the 120?
At the pretrial release department at the Van Zandt County Community Supervision and Corrections Department, 450 East Rose, 450 East Rose, Kansas, Texas, 75103. Look them up on the internet. Okay.
Okay, thank you.
I'm sorry, it's 250 East Groves, 250 East Groves. It's 2 blocks north of the courthouse.
Oh.
All right. Have a good day.
Thank you.
The only other two that I'm supposed to have here are out in Covey.
It's Michael Shane Covey or Covey here. Michael Shane Covey. Covey. All right, his name's been called. He's not present. I'll have his name called loudly, distinctly 3 times. Robert Crane.
Sorry, Mr. Couch is supposed to be here for a rain.
Is Joseph Brian Couch here? Joseph Brian Couch for arraignment. His name's been called, not present. Do you have information? No. All right, and then CR 2156, State versus Robert Cecil Crane Jr., set for arraignment, verified in Wood County. Go ahead.
Your Honor, the state has filed a motion to hold bond petition on Mr. Crane. I believe that should be in the court's e-file queue. I believe Mr. Knoll has received a copy of that, has no, I don't see for you, but my understanding is he has no objection to the circumstance.
I think the court's already signed that without a hearing. I'm going to double check that.
This train has actually 2 additional felonies in Wood County, one similar charge here, and I believe the other is assault on it. Assault. We'll be there a while.
Yes, I think the court signed that motion, signed that order granting that motion on June 24th, and I set bail at 500,000.
Okay, thank you, Judge. I just want to make sure we're full.
All right, so let's set Mr. Crane then for us arraignment. I know he's going to be a while, so let's set him on that August 12th. At the very least, it'll be a status. I don't want to lose track of him.
They're going to take your small business back to the court about 10 and see if they can show that.
Okay, yeah, that'd be good. I appreciate it. Mr. Manning?
Yes, sir. Ready on morning or rain?
Christopher John Morgan, CR 2403.
Judge, I have not seen her, but may I approach?
Yes.
That's a motion. That's to work. By the state.
All right, court also finds that Mr. Morgan has failed to report to pretrial release and has failed to pay any of his pretrial release fees. So I'm gonna take the motion under advisement until the next setting.
Yes, sir.
Do you believe that you could be in contact with Mr. Morgan?
I've attempted to call him previously this week to discuss this with him. I've been unable to get a hold of him.
All right, I'm gonna reset Mr. Morgan then for July 15th. Perhaps you can get a hold of Mr. Morgan and tell him what you've tendered to the court.
Yes, sir.
And I would like to have his delinquencies satisfied at $180. So I don't, all right, so July 15th. And I'm gonna set it for motion to dismiss.
Would you like me to issue a reset form or just you get it sent?
You'll just communicate that to him. Who else did you say you were ready on?
Mr. Albert Rayner.
Albert Michael Reyna, CR 2132. Mr. Reyna is set for docket call today.
Yes, sir. We're set for Dr. Call. I can prepare today. Now it's ready to review the discovery, discuss the best offer that's been given by the state with my client. However, I'm going to inform me that he is requesting time to find a retained attorney. He's contacted one already since he's got a couple other lined up. I told him the court policy that we are at Dr. Call and we are now ready. Now it's ready.
Mr. Reyna, do you want to hire an attorney to represent you? How are you going to do that? You don't even pay your bond supervision fees.
She, house right now, come back to Manchester, she wants to be up there, so she's gonna pay whatever it takes.
Whose house burned down?
My mother, house right now, so my wife's been going back and forth, but she's pregnant, been rest, and trying to help her out, so she wants to try to get us moved up there once all this is solved and see what happens, so, she's gonna try to help me out a little.
Well, Mr. Reyna, I was about to talk to Mr. Manning about your delinquency on your bond supervision and whether you should even go home today. Say again? Yeah, I show that you're $120 delinquent, that you haven't been reporting and paying your bond supervision. Really? So hang on. So if I go and look at my file and I find some bond conditions signed by you and me that say that you're going to pay, then you didn't know? Let me take a look. Let me take a look. You want me to take a look? No. Mr. Reyna. Mr. Reyna. Hush. Do you want me to go look or not? Then don't stand at that podium and tell me nobody told me anything about this. How old are you? 35. You're a grown man, are you not? Don't come in here and insult my intelligence. Do you understand? Go have a seat over there. I'll deal with you in a minute. You ready on anybody else?
Judge, Mr. Calixto is my client, and said he was not there at this point in time. He'd like I could wait around and go back to the office and come back.
I've announced his name. Did he appear at the last docket?
He did, Judge. He was late.
Well, I need you to stay here for Mr. Reyna, if you don't mind, for just a few minutes. I won't hold you over very long. Ms. Thompson, are you ready? Yes, ma'am.
We'll go ahead and hand this to you for him.
Tristan Martin, CR 20180. All right, Mr. Martin, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. You are Tristan Martin, correct? Mr. Martin, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Ms. Ann Thompson. Are you pleased with her representation of you? Feel like you've had enough time to talk with her about your case and have all your legal questions answered? Mr. Martin, is there anything about the paperwork that you've read and signed today that you do not understand? Ms. Thompson, do you believe Mr. Martin to be competent today? All right, and I see here that the proposed plea agreement is that Mr. Martin would be pleading guilty to a state jail felony offense of abandoning or endangering a child with criminal negligence under section 1244A, with the recommendation being 72 days in the county jail with him receiving credit for time served, $2,500 fine, $290 court costs, and $590 reimbursement fees, with him receiving 72 days credit for that, towards that sentence. Is that your understanding of the plea? And that's what you want me to approve, Mr. Martin? All right, under the law, the range of punishment for this offense is confinement in, if under 1244A is confinement in the Van Zandt County Jail for a period not to exceed 365 days and a fine not to exceed $4,000. I find that the proposed plea would fit within the range of punishment. So understanding that, Mr. Martin, then how do you plead to that offense? Do you plead guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court accepts Mr. Martin's plea of guilt. Any objection to states one? States one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? I think I recall this case with Miss Amber Martin. I think. Is CPS still involved in this case? Not with her. Sir, go ahead. Where are the kids now? Did they place, they went through like a custody plan and placed them with your mother? Were your rights terminated? You know, Mr. Martin, it's pretty sad when I read this that we've got kids that are testing positive for methamphetamine. I mean, you as an adult, you want to take that risk and you want to go and put that in your body and destroy yourself and destroy your life and do those things. Now, you have every right to do it. There's legal consequences that go with it. I'm not telling you anything you don't know, but what I'm telling you that you might not know is that is just not fair for a child who has no right, who has no ability to consent to that, has no ability to remove themselves and to be subjected to that. It's just, it's heartbreaking. It's very disappointing. All right, court's going to follow the plea agreement in this case. Court hereby convicts Tristan Martin, finding that there is sufficient evidence to support the plea of abandoning or endangering a child with criminal negligence. Court assesses his punishment under section 1244A of the Texas Penal Code at 72 days confinement in the county jail. Court awards him 72 days credit for time served towards that sentence, assesses a $2,500 fine, $290 court cost, $590 reimbursement fees. Mr. Martin, when are you going to be able to pay off the money that you owe? You understand that the payment plan is an opportunity to keep you out of jail, but you understand that if you go down there and tell her you're gonna do a payment plan and you don't make an effort to do that, and you don't do your very best to pay it off, you understand what's gonna happen, right? What? You're gonna go back to jail. That's right. All right, Mr. Martin, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward here to be fingerprinted. Burns, can you assist me with that, please? Come up here and see Miss Burns here. She's gonna fingerprint you and then you'll be free to go. Yes, ma'am. Thank you. And Karen, here's a motion to pay. I'll put over here to go with that. Ms. Beasley? No, that, yeah, I hate it. Good morning. Matthew Boyce, CR 16395, CR 17399. All right, Mr. Boyce, if you'll raise your right hand, I'm gonna place you under oath. Mr. Boyce, do you swear that the testimony that you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you put your hand down. All right, you are Matthew Boyce, correct? And Mr. Boyce, are you a United States citizen? And do you read, write, and speak English? Ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Miss Debbie Beasley. Are you pleased with her representation of you?
Yes, sir.
Feel like you've had enough time to discuss your cases with her and have all your legal questions answered?
Yes.
Anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Ms. Beasley, do you believe Mr. Boyce to be competent? You've explained to him his legal rights?
Yes, sir.
All right, Mr. Boyce, in CR 16395, you are charged by indictment with the state jail felony offense of theft of property less than $2,500 with 2 or more previous convictions. Actually, that's the same charge in each one of your cases. I see here that the plea agreement would be for you to plead guilty and proceed under section 1244A, which means that the range of punishment for these offenses cannot exceed 365 days in the county jail or a fine to exceed $4,000. I see the plea agreement is that you are to receive 1 year in the county jail with credit of 365 days, complete credit for that 1 year towards your sentence with restitution, court costs, and reimbursement fees. Is that what you're asking the court to approve today?
Yes, sir.
All right, understanding the range of punishment, then how do you plead to theft of property less than $2,500, 2 or more previous convictions in both CR 16395 and CR 17399?
Guilty.
And Mr. Boyce, are you pleading guilty to each one of those causes because you are guilty of committing each of those causes?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt. Ms. Beasley, any objection to states 1 in each case?
No, Your Honor.
States 1 is admitted in each case respectively. And the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
And I see that there's restitution in one case, no restitution in the other. Does that mean property was recovered and there's no claim?
We reached out to both victims in 399 restitutions for the 2 checks we received in 395. We reached out to the victim, no restitution was requested. These victims, assume that means they got their property back or they've written off.
Same victim in each case?
No, Judge, in 395, in East Texas, in 399, approach the two checks.
Okay. All right, then based on the court's review of the evidence, I do find there's sufficient evidence to convict Mr. Boyce. Court will follow the plea agreements in each case. CR 16-395, the court convicts Mr. Boyce, assesses his punishment under section 1244A at 1 year in the county jail, awards him credit for 365 days towards that sentence for time that he has spent in jail on this cause. Court orders him to pay $290 court costs and $815 reimbursement fee to Van Zandt County. CR 17-399, court convicts Mr. Boyce of that offense, assesses his punishment at the same under section 1244A at 1 year in the county jail with 365 days credit towards that sentence. Court orders restitution of $176.41 and orders court costs of $290 and reimbursement fees of $90. Mr. Boyce, are you going to be able to pay off any of the money that you owe in these cases today?
Yes, sir.
How much will you be able to pay today?
Uh,
And then are you gonna get on a payment plan to pay out the rest?
Yes,
And you're gonna be diligent about paying that off?
yes, sir.
You're not gonna make me come out and issue a warrant and pick you back up, are you?
No, sir.
You understand, though, that if you don't do what you're supposed to, you understand that I will do that, correct?
Yes, sir.
All right, Mr. Boyce, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. After that, I want you to report down to the end of the hall on the left and speak with Miss Bonnie LaPrade about setting up a payment plan to pay off the rest of what you owe, okay?
Yes, sir.
Just come up here to this table right here to be fingerprinted. Mr. Manning, will you approach? Okay. All right, and Ms. Beasley, on Mr. Bostic, it's my understanding that he was making arrangements to pay some of the money that he owed. Has he done that? You may. All right, CR 2284 states tendered a motion to dismiss. Mr. Bostic, I appreciate you taking care of the financial obligations that you owe. court signing the motion to dismiss today. Before you leave, I do want you to go down and meet with Ms. LaPrade. There's some other cases that you appeared on years ago that you have some financial obligations. I want you to go down there and talk with her about figuring out how we can discharge those so we don't have to issue a warrant for failure to pay. And so we're looking for just some kind of effort, even if it's $10 or something. Go down there and tell Ms. LaPrade what you can do. And so let's see if we can't work together to get that taken care of so that we're not back in, okay? All right, you're free to go. Yes, ma'am. Yes, ma'am. Let me meet you here. Adrian East, CR 2244. Get back here to you. They've changed my docket up. Yep, I went right past it. Okay. All right, this is CR 2244, State versus Adrian Ladon East. Mr. East, if you'll just raise your right hand, I'm going to take some brief testimony from you this morning. Mr. East, do you swear that the testimony you get to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Mr. East, I hold in my hand a document that says waiver of jury trial. This indicates to me that you have spoken with your attorney, Mr. St. Julian, about what it means to have a jury trial. Is that right? You understand that you have the absolute right to have the case tried before a jury of your peers? You understand that during that jury trial, you have the right to confront and contest the state's witnesses and their evidence. You understand that no one can take that right away from you. And if you choose to waive that right here today, then that right may not be restored to you. And there's really only very limited circumstances that it could be restored. You understand that? And you've counseled with your attorney about that. And you want to resolve your case by plea agreement. Is that right? Okay. Court will, and let me ask you one more question, Mr. East. Has anyone threatened, forced, or pressured you to enter into this waiver of jury trial? All right. Court will find that Mr. East has been admonished of his right to a trial by jury, has intentionally, knowingly, and voluntarily waived that right in open court, has been joined by the attorney for the state and attorney for Mr. East. Court will approve the waiver of jury trial. State, Mr. St. Julian said that he would like to set it on August 12th for plea. Do you have any objection to that? Okay. All right. So Mr. East, we're going to set you to appear back before the court on August 12th at 9 a.m. to enter your plea before the court. Is that plea going to be time? Is it going?
Yes.
So we need to do it in the afternoon. So we'll set it at 1:30, Mr. East, and you will report at the Van Zandt County Jail out on Highway 64 at 1:30. And we will have jail court there. You will be zoomed into this court, but you'll report out there at 1:30. Okay? Morning, Mr. Stevens. The other Blevins. Miss Eisel came and told me all about it. She felt horrible. She had this sick look on her face. Luckily, you were not far. Richard Blevins, CR 16397. Mr. Blevins is set for a motion to revoke today.
Judge, I just met with Mrs. Blevins for the first time. I don't know, a few weeks ago, we got contacted each other. I spoke with Ms. House, and she doesn't have an offer from me yet. However, she will have one, let's say. We would ask to restate it, but not to put it on a contested docket. I do believe the work is still.
You available August 10th or August 12th?
The 10th would be better, Judge.
Okay. We'll set Mr. Blevins in for August 10th. And that'll be at 9 a.m. So Mr. Blevins, understand you're still on probation. Still have to report, pay, drug test. And if you violate your conditions of probation between now and that time, probably rest assured that the state would amend their motion to revoke or adjudicate and allege those new violations against you. So you know what's in your best interest. All right, once you sign this notice of setting and you get the yellow copy, then you'll be free to go. Do y'all need Mr. Blevins at all to check in? So go ahead and go report to your officer while you're here today. Good deal. Thank you, Mr. Blevins. Yes, free to go. I think that's the only one that he has. It's not either, that's either here or not in custody. We'll go for Yes, she's over here. Yeah, you're right. Mr. Adams, you ready? All right, is this Ms. Kofer? Ms. Kofer, I called your name at 9 a.m. You were not here. If that happens, you need to call the court and at least give me a heads up. Otherwise, I write on the note, send Ms. Kofer to jail. That's what I write right here. And I give it to the officers and they make it happen. All right, this is CR 2285, CR 2320, State versus Rochelle Lynette. Kofer, set for docket call.
Yes, Your Honor. We received all discovery from the state as far as I can tell. Discussed with Leon, she's advised that she'd like to have a jury trial. So I'm announcing ready for that. In addition to that, Your Honor, in light of Ms. Kofer's travel situation and physical limitations, she wants to be paid. I'd asked the court to give us a special setting so that she's only come back for one more day.
Just for purposes of the record, what was the offer that she's rejected? $18-month state jail. Was there a fine? And is that on, what about the DWI? So conviction, time served. Is that the best offer the state's going to make in this case? All right, and so you've counseled Ms. Kofer on the fact that if she rejects that offer and then later decides that she wants to accept it before her jury trial, that the court may not allow her to plea.
I haven't told that specifically, Your Honor. She's hearing it right now.
You understand that, Ms. Kofer? If you're not able to work your case out and I set you on the jury trial docket, and then later you decide you want to accept that or another offer, the court may not allow you to do that. I may just have you go ahead and go to trial, and either if you're convicted, then the jury will decide or the court will decide. You understand? All right, the court's going to deny this request for a special setting. I don't believe Ms. Kofer's limitations or the nature of the offense demands a special setting. So we're going to place Ms. Kofer on the jury selection docket for Monday, August 2nd. And so Ms. Kofer, you'll have to report at the courthouse in the basement, not here in the courtroom, because we'll be picking a jury up here. You'll report down in the basement of the courthouse. My staff will be down there to assist you with paperwork and resetting your case if your case doesn't go to trial. And it's not set, number one, to go to trial in August. So you're going to continue to come back until your case gets to the top. Okay? And I want you to make sure that you're reporting to your pretrial release officer, checking in and doing all of those things that you're supposed to do. CR 2293, State versus Tristan Michael Kimmerling. Mr. Kimmerling has been verified in custody in Wood County.
That's right, Your Honor. I checked just a minute ago, and he's still in Lee County. He's being held on two different charges. Bonds total $15,000.
Do you know what type of charges those are?
One's a burglary, I know for sure. The other one, I don't recall off the top of my head, but the bond is higher, so it's gonna be more serious than one.
Let's set Mr. Kimmerling then for a status, the same thing we've been doing. Let's set him out till. Do you have your calendar for September? September 14th or 16th or somewhere that week?
16th,
14th. All right, we'll set Mr. Kimmerling then for another status on the 14th. Yes, sir. All right, CR 2410, State versus Jessica Lee Sotelo. Miss Sotelo, you can just stay right there. Just have a seat right there. All right, we're set for a docket call today.
Yes, Your Honor, I received all discovery from the DA's office. They've extended an offer. I will lay that out on Ms. Sotelo. She's advised that it's not an offer she's willing to accept, so I'm going to have to ask for a trial. She's informed me it's still shopping for retaining counsel.
What's the offer that she's rejected?
Oh,
But I believe it's 6 months state jail.
that's correct.
Is that the only offer from the state? There's not a time or a save P or anything of that, just 6 months state jail?
That's correct. This comes out of the CPS case and our offer is reflected for CPS cooperation.
Better size of several times now, put it on. That's.
All right, court will place Ms. Sotelo then on the jury selection docket for August 2nd. Court also wants to inquire into the result of the urinalysis test. And can you step around here to where we can get you in front of Miss Allen here so she can take your testimony? All right, and Officer Chair, if you'll raise your right hand, ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got. All right. And so the court ordered Ms. Sotelo to be administered a urinalysis exam. Did you do that today?
She admitted.
All right. And what did she admit to and when?
June 16th, she snorted cocaine. Also June 16th, she smoked
Mr. Adams, any questions for Officer Matura?
So. but-
It's not our policy, actually, like she-
State any questions for Officer Matura?
I'm sorry, I missed that last exchange. What was Mr. Adams' question?
My question is that our policy to not test. Didn't feel like it was necessary for us to-
Your Honor, I have no further questions.
Mr. Sotelo, you've left me really limited options here. Court's going to find that your bond is insufficient in this case due to your violation of pretrial release, use of controlled substances. Court's going to find the surety bond posted in the amount of $15,000 is insufficient. Court's going to increase Ms. Atolo's bail to $50,000.
That's 50.
50. So if we can have Ms. Atolo taken into custody, restrained. Thank you. Is that all you have, Michelle? If you'll approach, if Mr. Weiner, are you ready? Okay, Mr. Manning.
He's informed that he will be able to receive some of this, along with the balance. Next place is process to do, so. And be ready to release that.
Mr. Reno. All right, Mr. Rainey, we're going to hit a reset button, you and I, you understand? CR 2132, Mr. Rainey is set for docket call. Remind me again what the announcement from the defense is.
Judge, we can compare to today to when I was ready. Mr. Ray has informed me that he would like more time to retain counsel. At this point in time, my announcement would still be ready. On behalf of my client, I asked that he has some time to reset, maybe it's the 15th, to be able to retain counsel.
And when does Mr. Rainey believe that he's going to be able to make his payment towards his pretrial release?
He's going to be able to do that today.
And what's the offer that's been made to Mr. Rainey?
Previous offer was 45 years. I negotiated that down, 25 to life, got it down to 10 years at last second.
Are there enhancements alleged in this case?
Yes, Judge.
And so the offer was, what was the original offer?
45.
45. And you were able to negotiate with the state and get them to agree to withdraw their enhancements and recommend 10 years.
That's right.
And Mr. Reyna has rejected that.
At this time, based on my discussion with yes, Judge.
All right, court's going to place Mr. Reyna on the, well, and let me ask before I place you on the docket again. Is the state going to maintain that offer after today, or does the offer go back to something above 25 to life, or will there be an offer at all?
Judge, I believe the court sets Mr. Rain for jury selection. We would
Just so that I believe Mr. Reyna needs to be in the best position. You believe, or it will, or it won't?
if the court sets Mr. Rain for jury selection, we would.
How long has Mr. Reyna had to consider the offer in this case? Do you know?
We had since the last setting. He came into my office, we went over all the discovery, reviewed that, mitigating exculpatory information, conveyed that to the state, and the offer remained where it was.
Judge, we made that offer by 28, so.
And you believe that's the best offer the state's going to make in this case? And so he's had, how long? About a month to think about it. All right, Mr. Reyna, so you understand that by rejecting the offer today and going to trial, the court may not allow you to plea bargain after this. You understand that? And that's what you want the court to do? All right, court's going to place you on the jury selection docket on August 2nd. You're going to report at 8:30 down in the basement of the courthouse. If your case is not selected for trial and it won't be on August 2nd, then my staff's going to assist you with paperwork and they'll give you your next setting. Mr. Manning is not going to be required to be there until the case is within the court's top 10 and he's notified. I expect $120 to be paid today. If it's not, I will set you for another hearing and we'll come back in here and I'll decide whether or not you sit in jail and wait for your trial or if you're on bail and wait for your trial. Now, you said that you're looking to move where? Oklahoma. So you're wanting to move out of state? When you plan on doing that? Do we have conditions that he can't move out of state on pretrial release? No. All right, once you sign your notice of setting, get the yellow copy, you're free to go. Is Calixto Rosa here? Okay, sorry.
Judge, he was in the courtroom and asked to step out to see his saying he's sick. And I would request if we said, we have a deal negotiated with the state. But like I said, at this time, I don't believe that Mr. Rosa has a condition to be able to take it.
We're set for pretrial today. Do you have any contested pretrial motions?
We do not.
Any objection by the state?
Yeah, we do.
And it was brought to the court's attention when Mr. Rosa appeared. So court will set Mr. Rosa then for docket call on, do you want the 12th, you want August 12th or 10th, Mr. Manning?
Judge, we do August
10th? All right, we'll set Mr. Rosa then for August 10th. And if you'll take that notice of setting to him and then bring back the white copy, I'd appreciate it, Mr. Manning. Is that all you have, Mr. Manning?
10th.
Yes, sir. Thank you for waiting on me today. Mr. Weiner?
Hey, Judge, page 4,
Wendy Paul, CR 2352. Pretrial release has indicated to me that Ms. Paul has tested negative today on her UA. All right, we're set for status.
That's right. The last time we were here, my client was in custody of Coffin County Jail. She's since been released, obviously. I'd like, my setting here was a docket call. The first setting is subbing in on the case. I'd like one more docket call, just so we can kind of figure out if we can work this out in collaboration with the Coffin County case. I'm not wanting to string it out forever, waiting on the Coffin County case, but at least like to establish contact with the lawyer out there and kind of figure out what's going on.
Any objection from state?
No, you're right.
August 10th or 12th? Mhm. You need to see her. Yeah. Okay, we'll set Ms. Paul then for docket call on August 12th. Ms. Paul, once you sign that yellow copy, Mr. Weiner's going to give you, you need to come over here and report to Ms. Wood or to Ms. Burns. Went way back in time with that one.
Hey, Ms. Wolf, you said Larry Bird.
Who said labor? Peggy did.
Larry Bird.
That's worse. That's worse. Old habits die hard. Old habits die hard.
I'll see her.
That's all I have.
Yes, thank you, Mr. Weiner. Mr. Schmidt, who are you ready on? Everybody. James Bustamante, CR 21-9. No, you're right, still not here. Daniel Garcia. CR 2079, Mr. Garcia set for docket call. Can you put on the record what the offer was that he's rejected?
Judge, in the statement, 12-year.
And I'm assuming there's enhancement paragraphs alleged since this is a third degree. All right, Mr. Garcia understands that rejecting the state's offer today means that he may not be allowed to accept that same 12-year offer after today. All right, court will set Mr. Garcia then for jury selection on August 2nd. So Mr. Garcia, you'll have to report down in the basement of the courthouse at 8:30. Your case is not reached for trial and it won't be on August 2nd. You'll receive a new notice of setting that will have your new date. We'll continue to do that until your case is resolved, okay? Okay, but okay, come on, share some. This was I think it's 8th grade. We were on a trip to watch the release. This might be Clayton Market back here.
Looks like it.
Kids go, I need to ask her. Stacy Heflin, CR 2172, CR 2173. Mr. Schmidt. I'm gonna need her to sign this one. Well, she's not admitting nothing. All right, Ms. Heflin, if you'll raise your right hand, please. Ms. Heflin, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you put your hand down. Ms. Heflin, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? Are you currently undergoing any type of treatment or on medication for depression? Do you feel like that medication is assisting you and helping you have rational understanding of the proceedings today? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your cases with him and have all your legal questions answered? Anything about the paperwork that you've read and signed today that you do not understand? Mr. Schmidt, do you believe Ms. Heflin to be competent today? you've seen any type of evidence that her depression has affected her mental ability at all during your representation? All right, Ms. Heflin, you are charged by indictment with a third-degree felony of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams in CR 2172. That carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. Do you understand that full range of punishment? You understand that if I approve this recommendation today for you to be placed on deferred adjudication for 3 years, if I approve that and you get on community supervision and you subsequently violate your community supervision, the state could file a motion to adjudicate your guilt. Can we help you, ladies? Can we help y'all with something? Okay. They could file a motion to adjudicate your guilt, and if they prove that you violate in any one way of any of your conditions, the court could hold a hearing, could adjudicate your guilt. That means convict you, make you a convicted felon, and the court could revoke your community supervision and assess your punishment anywhere between that 2-year and 10-year range. Understanding that, you still want to go forward with this plea? How do you plead? How do you plead to third-degree felony offense of possession of controlled substance? And Ms. Heflin, are you pleading guilty because you are guilty for no other reason? Has anyone threatened, forced, or pressured you to plead guilty? Court will accept Ms. Heflin's plea of guilt. And Mr. Schmidt, any objection to States 1? States 1 is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, court finds that based on the review of the evidence, there is sufficient evidence to support this plea. The court will follow the plea agreement in this case. The court will defer a finding of guilt, places Ms. Heflin on 3 years deferred community supervision, orders her to pay a $1,000 fine, $180 restitution, $290 court costs, orders her to reimburse Van Zandt County $935. Court takes into consideration under section 1245, CR 2173, DA 2021-88, possession of controlled substance, and DA 2187, possession of marijuana less than 2 ounces. Ms. Heflin, how long have you had a drug problem? 30 years. Have you been to rehab? How many times? When was that? Of this year? How long was it? How are you trying to handle your addiction now? Are you doing it on your own, or are you in? That's good to hear. That's good to hear. Well, I want you to take advantage of any of the resources and guidance that your probation officer is going to give you. They're here to help you. They want to see you succeed. They want to see you stay drug-free, and they understand what it means to be a drug addict. Okay. So I hope you take advantage of that, and let's stay ahead of this problem. You have a great opportunity here to get additional resources free from the county. And so I want you to Give your best effort on community supervision. Okay. All right, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward here to be fingerprinted, and then you'll report to probation, okay? Yes, you do. Jason Hodebeck, CR 2121 and CR 21-172. All right, Mr. Hodebeck set for docket call today, and also arraignment. Have you had a chance to review the indictment with him in CR 21-172? All right, court will find that Mr. Hodebeck has waived the formal requirements of arraignment. Will enter his plea of not guilty in CR 21-172. Court will set Mr. Hodebeck for pretrial and the newer charge and docket call and the older charge. Is August 12th too early for you, Mr. Schmidt? You want to do that one? Okay. All right, we'll set both cases on August 10th. If anybody just had attorneys that they could talk to. Oh, they didn't show up. Hurry. They did. Okay. Sorry, Mr. Hodebeck, I'm waiting on Mr. Waddell. All right, Mr. Waddell, if you'll step forward. I asked that Mr. Hodebeck be tested for compliance with pretrial release. Has Mr. Hodebeck tested?
Results of the test today supply a sample that tested positive for marijuana. Upon conversation with the defendant, he admitted of using marijuana. The day he gave would be May 15th. That's what he told me.
May 15th,
Yes, sir.
which doesn't seem to be likely. Which wouldn't seem to be likely, right? Today being July 1st. Average still about 30 days. Could be a little longer.
Even giving a continual heavy user, sometimes 6 weeks.
If we sent that offer confirmation, would we get concentration?
Excuse me, he was already on conditions in April. Starting April 15th.
All right, Mr. Hodebeck, you left the court in a position to where I need to be consistent. I told Ms. Tolo, she's on bond, she violated, you're on bond, you violated. Can't treat you any different. So I'm gonna find your bond to be insufficient today for using marijuana while you're on pretrial release. So I want you to come forward to be taken into custody. And Mr. Schmidt, I'm just gonna double his bail. He was on bond with Mr. Roy Brockway's office for 10,000 on each. So it's gonna be 20,000 on each now. Charles Howard, CR 2176. Howard set for pretrial today.
That's correct, Judge. We had some issues with discovery.
Any objection from the state?
No, Your Honor, we had not pushed the button, it was actually pushing to him, and everything had been selected, just had the final step. We fixed that today.
All right, I'll set Mr. Howard then for pretrial on August 10th. And since Mr. Howard was late today, I'm gonna drug test him, Mr. Schmidt. So once he signs, and Mr. Howard come over here and have a seat. Louis Johns. Think so. Mr. Johns is set for docket call today, Mr. Schmidt.
That is correct, Judge. Received an offer from the state. So we checked it out, I believe, last place we were at. I think we were between 8 and 12. Judge.
The lowest and best offer the state was offering was 8.
Judge, I believe, to my memory, the last offer we made was 12. We do show that Mr. Johnson's 25 to life. We can put up the Indians.
All right, Mr. Johns understands if he rejects 12, then he might not be allowed to take advantage of that after today's date.
Yes, sir.
All right, court will place Mr. Johns then on jury selection on August 2nd at 8:30 a.m. Mr. Johns, you'll report down to the basement of the courthouse on August 2nd. And my staff will be down there with additional notice of setting to tell you when to come back, okay? You're still on conditions of pretrial release. That means you still have to report, drug test, pay, and do all those things with Mr. Waddell at the probation department. You understand? All right, and the court will, for the record, find that it's been reported to it that Mr. Johns, your analysis was negative. So, Mr. Johns, if you don't report over there, they're gonna tell me that you're not reporting, and I'm gonna bring you back to court, put you back in jail. Okay, so make sure you're reporting over there every month. All right. All right, once you sign that notice of setting, you're free to go. Christopher Mata, CR 2261. Mr. Mata set for docket call today.
We asked the Connecticut set.
All right, court will set Mr. Mata then to enter plea before the court on August 10th at 9 a.m. Douglas Mercer, CR 2264. Douglas Mercer. Still not here. Derek Piscata, CR 230. Mr. Piscata set for pretrial. All right, court will set Mr. Piscata for docket call on August 10th. And Mr. Piscata, after you sign that notice there and get the yellow copy, and come over here and check in with pretrial release. You'll need to sign your pretrial release papers. Justin Reed, CR 2406. Mr. Reed set for docket call today.
That's correct, Judge. We've had to go through the state. Original offer this morning. Peter, I'm going to do that and explain to Mr. Reed what that entails. We
Any objection from state? All right, court will set Mr. Reed for a final docket call on August 10th. Probably need to make separate ones so that they know, otherwise it's really good. Yeah. Mark Vargas. CR 294. Mr. Vargas set for pretrial. All right, court sets Mr. Vargas for docket call on August 10th. Mr. Vargas, I need you to report to pretrial release to sign some additional pretrial release papers. Ma'am, you can wait for him in the hallway. He'll come out another way. John Rigney. CR 2307. All right, Mr. Rigney's set for docket call today.
That's correct, Judge. Court's been writing this on the docket call plan. We do have state submitted, voluntary submitted a cell phone for analysis. We will see what they come. In addition, Mr. Reagan has come to me and asked for assistance with substance abuse problem. We're going to ask for 60 days to give Mr. Reagan an opportunity to check into an inpatient rehab. He has one available. I suspect that we can submit to that and be prepared hopefully with all the discovery to move forward on that 60 days.
Any objection from the state? Sorry. September 14th or 16th, Mr. Schmidt, 14th. All right, Mr. Rigney, the court's going to set you for a docket call on September 14th. Is that all you have, Mr. Schmidt? Okay. Going in. Talk to them. What I would like to do is sometimes I write over here what it is. It's a form where they show a positive. I like to do those behind this. We can see what with us that they violated, and we see how they violated. They admitted it's okay, and they tested positive. Yeah, they have a form. Take care. I don't always, I'm not much of a pride. What it is, so we'll know that.
Hey, that's okay. I'm not doing that. This is one.
I think it's, I'm saying it right here. On the record saying it. Yeah, that would be- that's right. Yeah. Okay, cool. What else?
Yes. He's clean.
He's clean? Okay.
She wants to.
Okay, we'll wait and see. so I have to wait until. Step out and call. Yeah. I told him 11 o'clock, so I ordered it.
Mr. Crane's in another hearing in Collin County, so if you need me to go get him, let me know, please.
Oh, no, that's okay. Let him finish and then just stay. I'll leave you in session. Just turn off
Okay.
your camera and mute. And then whenever he gets back, just have him turn on his camera and I'll know he's available and I'll move on
Okay.
to a couple others. But his,
Okay.
Ms. Olds is here.
Okay,
All right, thank you.
you're welcome. Let's see.
Ms. Olds, Mr. Crane is in another hearing. And so whenever he gets out of that hearing, he's gonna join us via Zoom, okay? Mr. Chaparro? All right, this is cause number CR 21, 11, 12, and 13, State versus Francisco Lorenzo Chaparro. And he is set for docket call today, Mr. King. I'll give you a second to get set up there.
There we go.
All right.
Good morning.
Good morning, sir. Sorry for the wait. We've had a pretty busy docket this morning. Mr. Chaparro is set for docket call today.
Yes, Your Honor.
And have you received an offer from the state?
We have, Your Honor, we have received an offer from the state. I don't think we're going to be accepting that particular offer, quite frankly, but so I'm not sure where that leaves us at this point. I don't know what the court's policy is about the first offer the state makes. And I don't know what the court's policy is in regards to if we don't accept the first offer they make, does it get set for trial? So the court can let me know what the what the pleasure is of the court. That's fine.
Let me see here. So Mr. Chaparro, this is his first docket call. So the way I do it, Mr. King, is we go from arraignment to pretrial to docket call. And between pretrial and docket call, it's my hope that the state and the defense are negotiating the case to the best of their ability and that the state makes their best offer if they're going to make an offer, and that the defendant counters with their best offers. And after at docket call, then I expect to hear either the best offer's been made and it's going to be accepted, or it's going to be rejected. And if it gets rejected, then I set it for jury selection. And whatever offer is rejected, I don't allow the defendant to later decide he wants or she wants to accept that offer unless there's good cause.
Okay, I understand the court's position on that regard. We haven't done much negotiation, to be quite honest with the court, in regards to the offer. I think if we talked about it, that I'm not sure that we could agree on what an appropriate offer would be.
Are y'all pretty far apart, you believe?
Pretty far apart.
Well, I'm gonna ask Ms. Heisel, what is the state's offer in these cases?
So that's the current offer is for 15 years CDC. At this point, I'm not gonna say that's the state's best offer. However, I will say Mr. King and I are still significantly far apart. But state would not be opposed to one more docket call for Mr. King to get with me to see if we could get a little closer.
That would be great, Judge. If we could do that, at least we could try to resolve our differences if possible. And if not, then we'll just put it on the trial docket. I know the court's got plenty to cook up there, but that may be where we have to go ultimately.
All right, do you have your calendar available?
Yes, sir, I do.
All right, I want you to look in August and look on August 10th or 12th and tell me which one of those you prefer.
Okay, I do need it.
August 12th would be best, Judge.
Okay. You give me a notice. All right, Mr. Chaparro, I'm going to give you this notice of setting. Thank you. It's going to have your new date on it. You're going to sign it. I'm going to give you a yellow copy and you're going to come back. You said, what day did you say, Mr. King?
August 12th, Judge?
12th, okay.
Yes, sir, please. And I'll try to get with the state next week, Judge, and see if reasonable minds can reach a reasonable compromise.
Yes, sir, please. I appreciate that.
Well, I don't think none of us need another jury trial if we don't have to have one.
That's true. So I'm going to set it August 12th at 9 a.m. for a docket call. All right, Mr. Chaparro. Go take that to him and we'll keep the white copy. He'll get the yellow copy. Once you receive that, then you're free to go, Mr. Chaparro. Remember, court starts at 9 a.m. Be here when I call your name. Otherwise, you may end up in jail, and that probably make things harder on Mr. King. All right, Mr. King, he's free to go. Thank you, sir.
May we be excused, Your Honor?
Yes, sir, you may.
Thank you, Your Honor. Have a good day.
You too.
Happy 4th of July.
Yeah, you as well. Bring in Mr. Pappas. David McLaren, CR 20263. Good morning, Mr. Pappas.
Good. I just checking. Can the court hear me?
Yes, I can. I can see and hear you. It's fine.
Thank you for getting us zoomed in. I appreciate it.
Absolutely. All right, Mr. McLaren is set for docket call today. Are we able to reach a resolution in this case?
We are not. The state has given me discovery. I have asked for a recommendation. I'm waiting to get one. I think there is a possibility that we can get it reconciled. I just need to get with the state and see where they are.
State, do you know where you are?
Judge, I believe we made an offer. I don't know if that has ever been made to Mr. Fathers. We could have another call so we can convey that. I have not been for resolution. Get there. We have a call.
All right. And so.
I'm sorry, Aaron, I couldn't. That was
I know
all.
you, I know you. Yeah, I know you can't hear him. So he said that he has made an offer. He doesn't know if it's been communicated to you, and he's not in objection to resetting it for an additional docket call. He believes that it could be worked out. So do you prefer August 10th or 12th?
Let me check really quick, Judge. I think that August 10th would be perfect.
All right, we'll set Mr. McLaren for August 10th. Pen is quit. Oh, no, there it goes. All right, Mr. McLaren. I'm gonna have you sign there on this notice of appearance, resetting you to August 10th at 9 a.m. And I'm sorry, and Rachel, I'm gonna need your help one more time. Also, you and I had this discussion last time about a processing order to get your fingerprints. I told you I was gonna need you to go out there and get fingerprinted, and then some court staff told me no, that you didn't. Turns out that you do need to do that. Okay, so I'm gonna have her bring you this order here. Take this order and take it out to the jail, present it to them so they can take you back there and get you fingerprinted. I'm sorry, I meant this one right here. It's okay. And the only other thing that you and I need to address is I show that you haven't been reporting to pretrial release. I'm sorry, that motorcycle or whatever that was. Say again. Okay, so what I want you to do is I want you to report back here to pretrial release. You'll get that. You'll come on back here. Just come on back. They'll explain pretrial release to you, and then you'll need to make some payments and you'll need to start reporting. Get this form. They're going to give you a copy of it. And then once you're through today, go out to the jail, show them that form. They're just going to take you in there, fingerprint you, and they'll let you go. All right. Thank you. All right, Mr. Pappas, we're done with your client.
Great. Thank you very much, Judge. It's always a pleasure. Good to see you.
Good to see you as well. Have a good day.
I'll follow up with the state. All right.
Yes, sir. Please. Thank you.
Thank you.
Mr. Byrd. Come on up. Come on up to the podium, sir. All right, this is CR 2148, CR 21108, State versus Zachary Dane Byrd. Mr. Byrd, I'm sorry, the court appointed, because you asked them to, you asked the court to appoint you an attorney. Court reviewed your evidence or your evidence on your affidavit of indigency, found you to be indigent, and we appointed Mr. Brent Gimble to represent you. And then a few days after that, Mr. Ron Harden filed a letter of appearance saying that he was going to be lead attorney on your case. Mr. Harden was instructed to file a motion to substitute counsel because I'd already appointed Mr. Gimble. He never did that, but he has filed a motion to withdraw as your attorney, even though he was never substituted in as your attorney. So I need to know, Mr. Byrd, who is your attorney? He said what? And so are you hiring Mr. So you're not hiring Mr. Hang on, let me finish. One of us has to talk at a time. My court reporter here, she's very talented, but when she's typing, she can't type what I'm saying and you're saying at the same time. So you're not hiring Mr. Harden to represent you on this case. Do you know why he filed a letter saying that you had and he was representing you? Okay, you need to get a hold of Mr. Harden. He should have been here today. He filed a motion to withdraw and he didn't show up. I don't know what he's trying to withdraw from because I've never recognized him as your attorney, but he put a letter in my file saying he is your attorney. So I need him here I will get Mr. Gimbel here. Mr. Gimbel was probably working under the impression that Mr. Harden's your attorney, because Mr. Harden showed up saying, I'm his attorney. And so Mr. Gimbel's going to quit working because he believes you've hired somebody. So we got a little bit of a mess going on here. So I'm going to reset you for a few days, and I want you to reach out. I want you to call Mr. Gimbel, and I want you to clear up any confusion on his part. And I want you to call Mr. Harden. And I want all three of you to come back on that date, and so I can talk to all three of you, so I know what in the world is going on. Okay? I want you to come back on July 13th. So that's going to give you a couple of, almost 2 weeks to get a hold of them, and you guys figure out what it is you're going to do. Oh, did you already fill out one, Patty? Oh, thank you. Mr. Byrd, I need you to come over here and report to pretrial release. Yes, come over. Mhm. So, yeah. Well, I've lost Mr. Crane. Don't see Mr. Crane. All right, for purposes of the record, there were other individuals on the docket today that the court had reset prior to today. On page 3, CR 2292 and CR 2292, State versus Devin Scott Key. There was a motion for continuance granted, and docket call was reset to July 15th. CR 2346, Sean Taylor Coons, motion for continuance filed and granted. Docket call reset to July 15th. Jeff Sanders' clients, Megan Bailey, reset to docket call 713. Charles Campbell, reset for docket call 713. Haley Gandy, pre-trial set July 13th. Travis Skinner, docket call set July 13th. My page 5, Randy Dobbins, motion for continuance filed by Mr. Ashmore, granted, pre-trial set August 10th. CR 2333, Grace Ann Fowler, Mr. Ashmore, motion for continuance filed and granted, docket call reset to July 6th. Jason Nichols, Casey Ashmore, pretrial reset on continuance to July 6th. Page 7, Mitch Adams. Oh, I believe we set that one in court. Let's see. Mr. Nolan White, CR 2171, Roy Lakeen and Hamilton, waiver of arraignment, e-file, pretrial set August 10th. Also on today's docket was CR 2379, Joshua Neal Brown. However, the court dismissed that on June 7th. Pled in another case, Nolan White, my page 7. Yes, please. Paul Douglas Mercer, CR 2264. Our Mr. Mercer is set for docket call today and also status on the UA confirmation that we took on June 24th, I believe. June 24th. What's the announcement on docket call? All right, record will reflect that Mr. Mercer has rejected the state's offer of 8 months, and state is that the best offer that's going to be made in this case?
Yes, sir.
All right, court will set Mr. Mercer on the course jury trial docket for August 2nd. No, I want Mr. Mercer to stay. We need to take up his issue of his UA confirmation. I believe that was probably May. Yes, I think they went to get him. So Mr. Mercer, just stay where you're at right there. If you want to, you can have a seat on that first row right there. Sure. Good morning, Mr. Crane. Looks like he's trying to figure out how to get his video on. So we'll wait. There we go. All right, Mr. Crane, can you see and hear me now? Mr. Crane?
Can you hear me?
Yes, you're a little bit muted.
I've got some kind of problem here. I'm not sure why I'm able to not hear you well.
It's better now. It's better now.
I don't know. The problem is, I don't know why it's not working.
No, I can hear you. Can you hear me?
I got an idea. Here we go. How about that? Better?
Yeah, that's much better. That's much better.
Okay, there we go.
All right.
Okay.
All right.
Good.
Court calls CR 2302 State versus Ashley Autumn Olds. We are set for the final docket call today. Have you been able to reach a resolution for Ms. Olds with the state, or are we going to move forward to a jury?
Yes. No, we reached a resolution. She has some kind of an inpatient or, outpatient treatment that she's agreed to sign up for. And this will not lead to a revocation of her parole. And the prosecutor has all the details on that.
Judge, if we could set this for.
Here, come up here so he can hear you, because those aren't not even on.
Judge, if we could set this for a plea at Mr. Crane's convenience, we'll do the paperwork and we'll get it resolved.
Okay. So
Fine.
can we set her do we want to set her for a plea like in a couple weeks or a month or what?
Either way, at Mr. Crane's convenience is fine by the state.
Mr. Crane, what do you want?
A week or two is more than enough, sir. I'd say after the 4th sometime.
How about, would she be would this be probation time or would it be time?
She's not going for time, Judge.
Okay. All right. How about either July 13th or July 15th?
July 13th.
July 13th?
Yes, sir.
Okay. All right, Ms. Olds, we're going to set you for a plea on July 13th at 9 a.m.
Very good.
And Judge, we will have the paperwork ready.
Okay. We're going to bring this form to you, Ms. Olds, for you to sign. Oh, did you have one here? I'll do it. Yeah.
Also, Your Honor, if you have an afternoon setting, that would be better, but we can do the morning of the 13th. That'd be fine.
Well, the afternoon settings are reserved for my jail cases. And
Very good. Then the morning will be fine.
now, if I can set it a little later in the day, I can set it like at 11 a.m. or something, if that helps you.
Yeah, that would be perfect.
Okay. So we'll set it at
Thank
11 a.m. Ms. Olds.
Thank you very much.
We'll write that on here.
Very good. Thank you, sir.
You're welcome. All right, Ms. Olds, she's going to bring this to you, sign this, and we're going to give you the yellow copy. And we're going to come back on July 13th at 11 a.m.
Very good. Thank you, Your Honor.
You're welcome.
Mike.
Sorry for the delay today.
Oh, that's okay. It's my fault. I got stuck over here in McKinney on 2 other hearings, so
Well, at
I
least,
appreciate your patience.
yeah, absolutely. Well, at least Zoom allows you to get all 3 done in the morning together.
Right. Exactly. Yes. Very good. Thank you, sir. Am
Oh,
I
you're welcome.
excused?
Yes, sir. You're
Okay.
excused. We'll see you soon.
Thank you, sir. Bye-bye.
Bye. Put that with the plea. Mr. Schmidt, are you ready on Ms. Hamilton? Ms. Hamilton, Brittany Hamilton, CR 2170. All right, the court has reviewed Ms. Hamilton's affidavit of indigency, finds her to be indigent on today's date, has appointed the Honorable Richard Schmidt to represent Ms. Hamilton. Mr. Schmidt, have you had an opportunity to go over the indictment with Ms. Hamilton?
Judge, I have, in addition, I did know Hamilton that, obviously, good ramifications for that door. As far as that is concerned, the Hamilton today, still includes the, maybe venture, she said, no longer her, legal name. Her legal name is Brittany Marlene Hamilton. However, that being said, she was charged with
All right, court will find that Ms. Hamilton has waived the formal requirements of arraignment. Her will enter her plea of not guilty into the record and will set pretrial on August 10th at 9 a.m. So the Easter eggs could be up there. You're still working on Mr. Mercer? Hang on, we'll go ahead and call it. We'll go ahead and call it. Mr. Waddell. Don't run off. If you'll come on around here. Mr. Mercer, if you'll step up to the podium, sir. All right, back on the record, CR 2264, State versus Douglas Keith Mercer. The court's already set Mr. Mercer on the jury selection docket for August 2nd. Court finds that on May 25th, the court had Mr. Mercer undergo a urinalysis exam to determine his compliance with pretrial release conditions. My recollection is that Mr. Mercer tested positive for or showed some sign of methamphetamine on that day in court, May 25th. And the court directed the Van Zandt County Community Supervision Corrections Department, Pretrial Release Department to send that off for confirmation. Mr. Waddell, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, if you'll put your hand down, will you give the court an update on the confirmation, if any, was received on the urinalysis exam?
Yes, sir. The sample was sent off to the lab in Tyler, Texas, and it was tested, and the results that came back to us on June 8th of this year showed the results as positive for methamphetamine. But it's the only substance that's considered positive. Yes, that was given that day.
Any questions for Mr. Waddell, Mr. Schmidt?
Did Mr. Mercer on the prescription?
Yes.
And did he inform you that it was on prescription?
And I believe that's, yes, sir. That was when we sent it off to the lab.
And the threshold amounts on the drug result, what is the threshold for the positive for the mass and from?
Can I get a copy of that? Can I see a copy of that? Just so I can review as y'all testify about it.
So, Mr. Waddell, the threshold levels for meth under EIA, and I believe that's the test that they performed, is 500 nanograms per milliliter, correct?
Yes,
And he is at what amount on his methamphetamine line?
397.
So as far as the mass spectrometry is concerned, it's below that threshold, correct? There is a different test where the threshold would be 250 nanograms per milliliter. Is that correct?
Yes,
And I don't believe that, I'm not certain if they did that test, but that's just barely above that, correct?
yes.
And so he claims that he's on prescription ranitidine, and are you aware that prescription ranitidine has a tendency to have a positive result from that?
I have heard that information before.
And, but Mr. Merchant denies using any controlled substances.
That was his statement.
Absolutely.
Mr. Woodward,
Mr. Waddell, based on the results that you've received, based on their analysis, the lab confirmed that there is the presence of methamphetamine. Is that correct?
Based on your test.
No further questions.
all right, anything else?
Judge, if I could call Mr. Mercer for the limited purposes of.
Thank you, Mr. Waddell. Mr. Mercer, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Go ahead, Mr. Smith. Why don't y'all come up here, because I'm not, she's gonna have a hard time hearing you talking that way.
Thank you. Mr. Mercer, state your name for the record. And you're on pretrial release conditions at public school. And one of those is controlled substance. Recently, you took a urinalysis test, and it had a presumptive positive. They sent it out to the lab and came back. For the purposes of the drug test result, it would be positive. Now, you've been in and out of the system quite a bit, correct? And you've been on prescription for medicine for quite a while.
Make sure you speak up, Mr. Mercer. I can barely hear you.
And did you frequently have positive
different cases in different cities that were positive. Pharmacists. It shows that lost part. I ended up getting all my cases in return, well after the fact, he's a return.
So are you telling the court at this point in time that you know shows positive, cases false positive, you are not using controls? Or would you mind taking it?
He's past witness. Any questions, Mr. Woodward? All right, anything, argument, Mr. Schmidt?
Judge, I would just say that you look at those test results. One particular type of test, which is fine. On the other type of test, it's too quick, and it's fairly well done. I think that my brief review of the science does suggest that humidity shows a positive method test, the threshold of 300 range. So that would actually sound. Other than that, I would suggest to you that those threshold amounts, if they're based on get those prescriptions and perhaps, or it's gonna be a whole issue. It's causing.
State.
I have no real argument against that, that does appear to sound reasonable. I'm not saying that I fully believe that that's the case, but it would seem reasonable. I would suggest that the court continue to monitor Mr. Mercer's is on the trial docket. If the levels remain the same and there is some evidence supporting that the state has no real objection to.
All right, court will reset Mr. We're going to keep him on the jury selection docket on August 2nd, but we'll have another status on the UA confirmation to allow Mr. Schmidt to provide the court with that information regarding the prescription drugs. We'll set that on August 10th. Yes. This is good. Mr. Mercer, when's the last time you made a payment to your pretrial release officer? It needs to not be a minute. It needs to be today. So when you leave, I want you to come over here and check in with them, and I want you to make arrangements to pay this down. You still got a big balance, and it'll be a lot easier for Mr. Schmidt to work with you getting ready for your trial if you're out of custody versus in custody. Okay? All right. Come over here and report to him, and you're free to go. All right, the court has called CR 2153 State versus Joseph Brian Couch. Mr. Couch was not present when his name was called. His name has been called loudly, distinctly 3 times in the courthouse with no response. Court issues a judgment nisi and alias capias for Mr. Couch. Court has also called CR 219 State versus James Daniel Bustamante. Mr. Bustamante was not present in the courtroom when his name was called. Court has had his name called loudly, distinctly 3 times in the courthouse with no response. Mr. Schmidt has asked the court to take the judgment nisi and alias capias under advisement until 5 p.m. today. The court will grant that request and take that under advisement. That has completed the court's morning docket, and we will stand in recess until 1:30, and we'll resume with the jail docket at the Van Dyke County Justice Center and also online.